This week on The Communicators, a representative of the European Union discusses its approach to intellectual property and copyright issues. This program was recorded on April 27, 2009.
Our guest today on The Communicators is Luc de Vigny. He is the chair of the working group between the European Union and the United States when it comes to intellectual property issues. We appreciate your time with us. And joining us in the questioning is Ananda Mazumdar with BNA. He serves as the writer for their patent, trademark, and copyright journal. Thanks for coming in.
Thank you.
When you talk about your title, how would you explain it to folks as far as what you do when it comes to intellectual properties, particularly between the EU countries and the United States?
Well, with the EU and the US is a cooperation since now a few years, an institutionalized cooperation if you want. To review issues of common interest, try to develop concrete actions, liaise with the business, which often is the same on both sides of the Atlantic because both our economies, American and European, depend heavily on intellectual property. You could argue it's the only, or one of the most important competitive advantages of our economies.
When you look at the two economies, you talked about common interest. What are some of those?
You mean, what are the common interests?
Between our two countries. Mm-hmm.
Well, if you go through different intellectual property rights, patents, that's relating technology, trademark, copyright, we also have geographical indications and designs, which are perhaps for the GI less cooperative approach, but we have to make sure that these rights are enforced abroad because IP rights are territorial. That means that you need, if you want the goodwill or an international instrument to make sure that these rights are protected in countries where our businesses are exporting. And of course, as far as Europe is concerned, we're heavily depending on our exports, and our exports are a lot also IP exports. So it's very important to combine forces.
So when you're talking with our folks here about intellectual property issues, you represent various countries back in the European Union. How do you balance all those needs of those countries compared to the United States interest as well? How do you balance and negotiate those issues, so specifically when it comes to IP?
Well, as I've said, apart from the sector of geographical indications where there's a couple of tensions, and also one or two issues, one in music, because in the US there is no law allowing public performance copyrights to be paid to the right holders. That's one problem, and there was a WTO litigation actually which we won on this one, but still not implemented in the US. And there's another issue which is for trademark. The Havana Club trademark cannot be registered in the US because of Cuban-related law, which is also something which has been declared by the WTO panel at the request of the EU, something legal. But apart from these two minor examples, the broad spectrum, actually, we don't have to divide because we have the same interests. I mean, you can imagine the countries in the world which are not respecting intellectual property or not respecting it enough, and there our interests would be very, very similar.
Mr. Mazumdar.
Well, you mentioned geographical indicators as a point of disagreement, mm-hmm. and I think a lot of people are aware of the Budweiser mm-hmm. issue as an mm-hmm. ongoing disagreement, and mm-hmm. there is quite a large gap between the way Europe treats geographical indicators and the U.S.'s traditional treatment of geographical indicators. Mm-hmm. Do you see any point of compromise between the two sides on this issue? Yeah,
it's not easy to summarize, so I'll try to do my best in 2 minutes. Well, first of all, this is a debate which is not taking part into the US IP cooperation group because by definition we only talk about our cooperation issues, but also lead the EU intellectual property WTO negotiations in the Doha development round, and there you have two negotiations pertaining to geographical indications. One is called the extension, which is to extend the protection of wines and spirits to the other product, and this is where advisor would come into. And the other one is the creation of a register for wines and spirits, which has been pending since 15 years, since the TRIPS agreement of the WTO has been signed in '94. Just a word on what we call the extension, to make it very simple. Today, if you have a wine or spirit in the world, which doesn't come from the place it says it comes from, and except if in the country where it is sold it is considered generic, or if there is a prior trademark or prior use, which are three very important exceptions we don't want to change. But apart from that, this product may not be called by the name which is not representing its origin. It may not be called style, type, etc. So in other words, you cannot have, and again, unless it's generic, which is a different issue, but because in the US you have many generics, but you would have like Côte du Rhône. You cannot have a wine that's called Côte du Rhône style, or Côte du Rhône kind. Now, for other products than wine and spirits, cheese, hams, but also from developing countries, coffee, rice, or even silk, like Indian silk, etc. There's few non-agricultural GIs. You may not call these products by a name which is representing the origin, but you have to prove that you are misleading the consumer. And that's a big problem, because on the one hand, for wine and spirits, you have an objective protection, and the other one, you have a subjective protection, which is a nest for litigation, because of course, prove that it's misleading the consumer is extremely costly. You need to have panels, and in certain countries, litigation is extremely expensive, and GI producers can't afford that. And so what we want to do by so-called extension, and I close the answer on this one, is to extend this protection to the other one. Now, for Budweiser specifically, first of all, Budweiser is not registered as per name in GI, for instance, even in Europe. It's only the original Czech name, České Budějovice, which is protected. The second more important point, and this is, I'll finish by that on the GIs in WTO, which is different from the EU-US IP group, is that because we are not putting into questions the so-called exceptions for genericness, that is to say a name which is customary in the language, or prior trademark or prior use, that means that no one in the world will have to abandon a market in which it is, because our proposals are only forward-looking. And so in that sense, for instance, Budweiser, would be not true to say that, oh, if the extension works, Budweiser cannot sell anymore in a country where it sells today, because it will always benefit of either the previously registered trademark if they have done so, or at least a prior use if they were selling already, or sometimes genericness, but not in the case of Budweiser probably.
I think in the last few years, the state of California has tried to acquire European-style protection for terms like Napa.
That's right.
For Napa Valley wine.
That's
Do you
right.
see support from some American sectors for the European point of view?
I think, but it's ironic because I'm here for the US Corporation. I'm only speaking so far of the only non-cooperative topics, but I'll answer your question. We believe very much that the issue of GI is not an issue like, oh, it's Europe trying to protect its name and the other ones don't have a name. That's not true. American producers, and Napa is an extremely good example, and I've spoken many times with them, is also willing to stop people free riding on the reputation which they have built throughout the years, because it's what it's about. Yeah? Now, nobody would like to be called Coca-Cola style. Nobody would accept that Fanta type product. Why should we accept Napa Valley wines? Now, Napa Valley, interestingly enough, and also because one opposes often GIs and trademarks, and it's not true. In Europe, most have both. If you have Cognac Martel, you have the GI Cognac next to the trademark Martel, and Europe is world's highest registration of trademarks. So it's not true, we don't want to protect trademarks as some would like to portray it. But Napa Valley, to go back to it, in Europe, has requested and obtained protection as a geographical indications. Now, they could have gone for trademark or whatever, they went for that. Which means it's also interesting for these people now, whether the Napa Valley producer will have sufficient access to those who are making US trade policy shift, that's a different issue. But I think it's very much important.
If we could just briefly stick on the non-cooperative issues, you mentioned
Yes.
Havana Club.
Yes.
Do you anticipate that the change in administration will bring any changes to the Cuba issue, which might result in change in stance on Havana Club?
Well, I don't want to get into U.S. domestic policy. I really like everybody what the President Obama has said about Cuba, that there should be a new policy. We hope that this policy will include respecting intellectual property rights which have been acquired from a Cuban government by our trademark owner, and so that Havana Club can be registered in the U.S. We can only hope. It's also a bit problematic for the US to preach, rightfully so, that other countries should apply WTO rules, etc., if itself, for two relatively minor cases, if you take the overall IP portfolio, but important, of course, for the companies involved, does not respect WTO rulings, decisions.
When it comes to intellectual property, one of the things that are talked about consistently is copyright and then counterfeiting.
Yes.
What's being done between our two countries? From what I understand, there's a long-term effort as far as coming up with some framework as far as how anti-counterfeiting efforts are being handled?
Yeah, there's two things. There is, on one hand, you have the EU-US Cooperation Working Group, which has come up with a number of results and actions. Now, one of these actions is a cooperation for the customs. And I give you two examples of what we've done very concretely to help the business. One is to have joint EU-US customs operations, which seems common sense, but not so easy to get law enforcement authorities. And a few months ago, there was an operation called Infrastructure, which in a few weeks was targeting counterfeit integrated circuits, which, as you can imagine, is a potentially very safety-related issues. Your car brakes are probably depending on this. And in a few weeks, they managed to seize 360,000 counterfeit integrated circuits between EU and US. We plan to extend that. So that's one example is the joint EU-US customs operation. Another example on the customs as well is to develop a so-called toolkit, which would allow companies who want to register their rights with the customs, so ask the customs to monitor their rights to make sure there's no counterfeit, to have a toolkit which is common for both, so that when you register with the EU and US, you can exchange, etc., and make life for everybody simple. So that's one example. Other examples of our cooperation include exchanging information through our networks of intellectual property attachés throughout the world, compare notes, compare information, possibly do joint démarches with third countries if we have a problem in common, which would often be the case. That kind of a practical thing. And then, I finished by that, but it's another wider chapter, is this new treaty. And I'm not sure when you mention anti-counterfeiting, whether you're referring to the anti-counterfeiting action of the bilateral EU-US group, or then there is this new treaty launched, those negotiations have been launched 1 year ago, called ACTA, Anti-Counterfeiting Trade Agreement. The substance of it has been released, the substance of what has been agreed so far, because it's not finished, has been released by both USTR and the EU Commission and all ACTA parties being EU, US, Japan, etc., on the website. So a lot of it is explained, and there is also a customs border chapter, etc. But I mean, I will not summarize here, 6 pages.
There have been some criticisms that the ACTA negotiations have been subject to too much secrecy. Mm-hmm. What do you say to the suggestion that the talks should be more open, and that there are concerns that ACTA might result in curtailing free speech rights in the internet by narrowing the fair use doctrine or interfering with whistleblowing or government watchdog activities?
Okay, these are two different questions. First, on the principle of secrecy. Well, I know that there is no international trade negotiations happening in public. I mean, there's none of bilateral agreements is happening in public. The WTO negotiations in DDA does not happen in public. So why this one? Well, secondly, and more importantly, we do not own what the other governments are saying. I mean, it's their property. It's their negotiating position. So we can't. No one can say what the others are saying. But what is important, and I want certainly to conclude and insist on that, is that we do feel that, of course, public should be informed, because otherwise you end up with this information, and I will come to your second question. And this is why we have organized 2 widely followed so-called stakeholders meeting, plus on the basis of release of a very comprehensive document of what ACTA has been discussing so far, because it's not finished yet. It's been widely followed. The one I did in Europe, there were, I think, 170 businesses and consumer groups, etc., registered. So it's as democratic as can be and as transparent as can be. Now, as you can imagine, the negotiating parties don't go to ACTA out of the blue. They come with their own background of legislation. In Europe, for instance, we have very strong legislation regarding private life privacy, etc., data privacy. So it's totally unimaginable that we would change that by going to ACTA. ACTA is about commercial scale counterfeiting piracy. It's not about personal iPods or personal devices. When it comes to customs, for instance, we have de minimis rules, which of course would be applied. So that's very important. The internet chapter specifically has not been addressed yet. So anything you would read or hear about it is totally rumor, because this is the only chapter which we haven't started discussing yet.
What's the essence of the internet chapter?
Well, there is none yet. I mean, the idea is, of course, that we have to address a phenomenon which is an objective phenomenon, is that not only you have piracy on the internet, but you also have counterfeit sales being held by internet. Now, obviously, this didn't exist by the time of TRIPS agreement in '94, certainly not in that magnitude, so you need to address it. How to address it? Clearly, there's conflicting views. On one hand, you will probably have the right holders asking for bigger control of the internet, but doesn't mean it has to be unreasonable. There are examples in Europe of ways of doing that. And of course, on the other hand, you'll probably have the interest of the internet service providers, the ISPs, who will be willing to do less, and we have to strike a balance between both. But as I said, we haven't reached that. This being, well, no, please.
Well, as a counterfeiting treaty, is there any
Anti-counterfeiting treaty.
Right? Is there any scope for regulating pure information exchange, or is it just the application of labels to products?
I don't understand what you mean by pure information exchange.
Well, there are some fears that the information that is owned or claims to ownership might be restricted, exchange might be restricted, but counterfeiting as a pure concept is not related to information, but rather labels applied to products.
Well, as I've said, we haven't reached that yet, so I have no idea what is going to be the proposal on this one. If you take the most extreme examples of, most extreme no, but the furthest reaching examples of internet regulation attempts, which in Europe have been failed last minute, but what you see in the content of the French draft law, the three-strike rule, that at first you receive an email saying that you are downloading illegal content. This is for piracy, it's not for counterfeiting. Second, you get a registered letter saying that you should stop it, and the third time your internet connection is terminated. By the way, in this project, the right holders did not have the information on who is downloading. They only have an IP address, but don't have the address. They have the IP address, anonymous IP address, and on the basis of what is being downloaded, they could ask an authority from the state to issue these warnings. But even then, none of this includes regulating information, so I can't see it coming.
How do you see factors? A couple of weeks ago, maybe it was even last week, the Pirate Bay company in Sweden, I guess, the developers of that Piers network were charged with, as far as downloading issues were concerned. Do those things stand up legally as far as the efforts that are being made? I don't know if you can comment officially on it, but when you see efforts like that being made by governments to stop these activities, what's the success ratio of getting actually a company to change its ways when it comes to people who use the technology to download?
Well, as you can imagine, as a European Commission official, which is an executive body, I have no comment to make on a judicial decision taken by a criminal court in one of my member states. I should note also that criminal sanctions for IP is one of the few non-harmonized in Europe issues, so what you may have in one country may be different in another one. But as far as I know, Sweden is a very democratic country, and if people are prosecuted and condemned, it must be on the basis of the criminal law. there is nothing new in the law itself. I mean, since the TRIPS, downloading illegal content on a commercial scale is liable of criminal prosecution. So it's nothing new. Perhaps what is new is that governments actually do it because they see a problem of magnitude, etc.
Well, given we accept that criminal sanctions are appropriate, what about the practical result that still might not stop the piracy if it moves to overseas or to a location that's harder to bring criminal sanctions?
Yeah, then you go back to not to the offer side, but to the demand side, and the French system of three-strike rules, or there are other systems that you could keep your internet connection, but you would have a reduced band width, so that you could have your emails, but basically not download illegal programs. In other words, you have all these solutions. I mean, nothing is perfect. The phenomenon is fairly new. I just take one point. I mean, if you replace the pirated music, say, or pirated films, and you replace that by hard copies, and you go to a store and you steal a few CDs or a few DVDs once and 2 times and then 3 times, and the only thing at the 3rd time is that you get banned from the store, is that big? I mean, is that a big of a sanction?
Doesn't seem inappropriate.
But because it's exactly that. Actually, it's even worse, because to be banned from the store, you'd have to steal on a commercial scale, which probably 3 individual CDs would not suffice. So you'd have to steal like hundreds of thousands of CDs.
When you come to...
But that's personal comment, I should say.
Of course.
Sorry.
When you come to the United States, who do you talk with? Is your work done mainly through the trade representative, or is it through the Department of Commerce? And
it depends. For one, for the EU-US working group, my counterparts were actually located in DOC. It used to be Chris Israel and Wayne Pogue. I understand the position has now been moved to the White House, but has not been fulfilled yet. But that would be my next counterpart for the EU-US working group. And then for international negotiations per se, like ACTA or WTO negotiations, it would be USTR. Have you
had a chance to deal with any of, since the change in the administrations, any new faces as far as you're talking to yet?
I haven't met new faces. No, I haven't. We haven't seen new faces yet. And actually, we're waiting for this administration to make up its mind on ACTA, because we were supposed to resume the negotiations early on this spring, and we understand there was a delay because of the change of administration. We just hope that it won't last too long, because well, you have a dozen countries plus 27 waiting to continue this very important international negotiations.
Yesterday, as we taped this, World Intellectual Property Day took place. It took place on the 26th. And one of the things that were talked about was the world of intellectual property, especially when it comes to, I don't forget where the quote came from, but as far as, I think, using it to help develop more research and development jobs, especially when it comes to green technology. Mm-hmm. What kind of efforts do those mean for a job like yours as far as negotiations are concerned?
It's a very important topic that's coming up, that probably will be discussed in the coming month. It's always the same with IP. You have to strike a balance between, on one hand, encouraging innovation and encouraging it by a promise of reward. On the other hand, limit the monopolies that it de facto, de jure gives. This balance has been achieved in other controversial fields. I'm thinking of access to medicines, where we've changed the TRIPS agreement by making special exceptions to allow compulsory licensing for countries who don't have production facility at home, etc. Obviously, there'll be discussions going around this green technology. The problem is, of course, that green technology is extremely far-reaching, even more than access to medicine, because I don't know, if you are Airbus and you make a fuel reduction system in your planes, is that green technology? Should it be given for free to any country that's willing to have an aerospace industry? I don't think so, but you have these issues, same for automobile industry, same for a lot of industries. So it's an important debate. I mean, in Washington here with 32 degrees, I think that no one can deny the climate change. Well, in April, it's fairly hot, I think.
Well, it is built on a swamp.
One more question we have time for.
Well, you mentioned striking a balance. I think the U.S. has found it difficult to strike a balance between trade with China and deciding whether to apply sanctions for failure to protect IP. Is there anything you can say about the European experience with China that might provide and offer a path to solution?
Well, China is, of course, very important. It's important because the magnitude of the trade we have with them, our custom statistics systematically indicate that the majority of the seizures of counterfeit goods, and we're talking of 80 million products, counterfeit products, we're talking about 58% come from China, so it is a problem. Also, domestically in China, we see that our companies are confronted with big problems of access to justice. The requirement to bring evidence in justice is just amazing. And so the magnitude of the problem is big. This being said, China has made progress, it's undisputable. Now the question is, has it made progress as much as it could, or should it be encouraged, between inverted commas, to do more? China has a very clear agenda to be #1 in a number of technological fields. I mean, it's officially their policy. You can read it on the Chinese government documents. The question, of course, is will they do that respecting IP? We were not co-actor in the litigation. We were observer in litigation between China and US. It's difficult on enforcement issue to imagine that, of course, one dispute will solve it all. I believe we have to continue a cooperation with China, and we have very big cooperation in China, and it goes from customs cooperation, which is quite efficient actually. We have dialogues with them where we deal with a number of issues. We go in concrete in details, and when we train, we have big training programs in China. That's very important too. And all that we cooperate with the US to avoid redundancy. But at the end of the day, and I think this is clear for many aspects of trade policy, you will have results if you are committed and if you are determined. Now, in some aspects of the trade policy, we are very determined. If we put anti-dumping duty on the country, it's pretty much a determined action. IP is more complicated, but I think we need to be determined because at the end of the day, it's our only competitive advantage.
Luc de Vigne with the European Commission. He works on a EU-US intellectual property working group in which he is chair. We're also joined by Ananda Mazumdar of BNA's Patent, Trademark, and Copyright Journal. To both of you, thanks for being on The Communicators.
Thank you.